News.
The race to replace retired Deputy Chief Justice Kalpana Rawal will be a battle between 10 serving judges and 3 lawyers, all of them women. Court of Appeal judges shortlisted for the Deputy Chief Justice interviews are Martha Koome, Agnes Murgor, Wanjiru Karanja, Philomena Mwilu, Fatuma Sichale, Hannah Okwengu, and Roslyn Nambuye, who has also been shortlisted for the Chief Justice interview. The High Court judges in the Rawal succession race are Abida Aroni, Lydia Chode, and Pauline Nyamwea, but they will be battling it out against lawyers Sarinda Kapila, Pamela Mwikali, and Joyce Majiwa.
There is a lot of arguments both sides.
While 18 applicants have been shortlisted for interview to replace retired Supreme Court Judge Philip Tunoi.
Each candidate for Chief Justice will be interviewed for 1 day, and for Deputy Chief Justice and Supreme Court will be interviewed for half a day. At the end of the process, one name will be submitted to His Excellency the President for submission to Parliament.
But the Law Society of Kenya has now written to the Judicial Service Commission demanding to know the criteria used to slash the list of shortlisted applicants for Chief Justice from 14 to 6. The 6 shortlisted applicants are Supreme Court Judge Smokin Wanjala, Court of Appeal Judges Al-Nashir Visram, David Maraga, Roslyn Nambuye, and High Court Judge Musaga Mbogoli and Senior Counsel Nzamba Kitonga.
What the JSC committee was supposed to look into in this first phase is to see whether the applicants meet the minimum requirements.
There may have been views of individual commissioners, but in the end, our process that commissioners persuade each other, and out of the reasoning of the commission in its processes, a decision is arrived at.
Probably outside the advert.
Although most of the applicants left out of the shortlist are yet to receive regret letters, sources within the JSC say some of the applicants who were academically qualified for the jobs were rejected on grounds of failing to meet the integrity threshold of Chapter 6, while others were found to be lacking in leadership qualities. Among the 8 rejected applicants for the Chief Justice job is law scholar Professor Makau Mutua and Supreme Court Judge Jackton Ojwang.
I would think within a process like this, which has huge and attracts huge public interest, that it would be only fair that perhaps they do not get condemned unheard, and perhaps that the reasons why they did not make the shortlist are communicated to them.
Those details are there, and as I said, they are kept as a record. I think any individual interested in that record would seek to apply for that record, but that record exists and it is there.
Now, with the names of all the shortlisted candidates finally out, the attention now turns to the members of the public who have 21 days to raise any complaint against any of the 37 applicants that have been shortlisted for the interviews. Muremi Mwangi, KTN News in Nairobi.
Good evening and thank you so much for joining us on The Last Word. My name is Sophia Wanuna. Delighted you could make time for us this evening. Tonight we focus on the race for the Chief Justice, who will be Kenya's next Chief Justice, Deputy Chief Justice, as well as one more judge that has been sought for the Supreme Court. That's the highest court in the land. Yesterday, the JSC releasing 6 names of the shortlisted candidates out of 14, and though JSC having the last word on that particular matter, it's a conversation and a move that has elicited a lot of debate, especially on social media. Kenyans weighing in on who they thought should have been on that short list, who they agree, in fact, making it would make for a good Chief Justice. We'll make our conversation tonight. We want you to be part of it as well. So 6 candidates being shortlisted for CJ position is Al-Nashir Visram, Smokin Wanjala, Roslyn Nambuye, David Maraga, and Nzamba Wekamba Kitonga and Justice Mbogoli Msaga. Tweet me at Sophia Wanuna. Which one of these would you prefer to be Chief Justice? Of course, also earlier today, JSC announcing the shortlist for the DCJ position. 13 candidates being shortlisted for that position as well. We'll canvass the same in the show tonight. But also what LSK is now demanding that JSC make public what criteria it used to reject the other candidates. And of course, my guest in studio tonight to help us through this conversation, my extreme right is Dunstan Amari, who's a lawyer, and also Nelson Havi with us tonight, a lawyer as well. We thank you for making the time, as always, to be with us on The Last Word. So let's begin with a demand or request, shall we call it, by the Law Society of Kenya to the Judicial Service Commission that it makes public the reasons and the criteria it used to be able to reject those now out of course, 8 candidates. We'll begin with you, Omari. Your thoughts on that? Should they make them public?
First and foremost, the demand or the request for publication of the reasons as to why some of the applicants were not shortlisted is grounded in law. Article 10 talks of provision of transparency in everything that is being done. 2, the law talks of, the Constitution talks of that any information held by any government or organ of government created by the Constitution is information for the public. And the institution holding that information is holding it on trust of the citizens of these countries. Therefore, the Law Society of Kenya is mandated and is right to demand. The question that goes beyond that is the JSC going to release this information? In my own understanding and perspective, I don't think it will be prudent to release this information. The reasons are being, one, some of the reasons that the JSC will have noted that made them not shortlist these people are on integrity issues. So the moment they release that information to the public, that so and so who applied has corruption-related allegations at the Anti-Corruption Commission. 2, he has issues with the Director of Criminal Investigation Department. 3, he has issues with the CRB in terms of he failed to pay the loans that he took for Higher Education's Loan Board for his or her studies, or he took a loan and failed to repay. These are fundamental reasons that will open up a can of worms, and people will say that then that person should vacate the position that he's holding. Remember, some of the applicants who didn't get to the list are sitting judges, are sitting commissioners, are sitting government officers. Therefore, I don't believe that JSC will want...
But isn't that a good thing? Because if there's reason for them not to be in the Supreme Court, then if it opens an avenue for people to then realize these other issues they face, then they perhaps shouldn't also sit in these other offices.
Well, Sophie, you know that those are allegations. The JSC didn't have the time and capacity to interrogate and put these people who have alleged this way to cross-examination. Therefore, the JSC will be exposing itself, one, to have made decisions based on information of other arms of government without verifying whether indeed that is the position. For example, when they say that some of the applicants failed the test of leadership, it is an amorphous statement in terms of what is the yardstick, what is the capacity, what is the threshold for leadership. So, in every interview, every application before the HR department, there is discretion in terms of, one, who they will shortlist. They must have also looked at the question of tribes. They also looked at the question of gender. They also looked at the questions of academic qualification. They also must have looked at the questions of, has this person ever had any leadership position? So because of that, I don't think that the JSC will want to embroil itself in sideshows. Instead, it will focus on the recruitment of the judges that it has banded to do.
All right. Do you agree that the JSC should make known the criteria?
The Judicial Service Commission has made a decision to shortlist 6 candidates out of an entire choice of 14 who applied. Now, with the requirement of transparency and accountability under the Constitution, it becomes quite clear that when a decision is made, it must be supported by reasons. And this is something that the Judicial Service Commission cannot run away from. Reason being, there is ultimate fidelity in the publicity of a decision made by a body of this kind. And I think the more reason as to why the Judicial Service Commission is obliged to do this is because they set out a time frame within which they were to review these applications. Within 14 days, they were required to make a cursory look at the application for completeness of record. Now, in public procurement, this is in the nature of the minimum entry threshold, a task that can even be completed in a clerical way. So, for instance, I do not think that within a day they had all the capacity to delve into the competencies of these candidates on account of leadership, on account of integrity, etc. Because the minimum requirements that were put upon these applicants are quite straightforward, actually paperwork considerations. And I think the Judicial Service Commission, having abridged the initial 14 days, the initial 21 days, the initial 30 days, within which they were to come up with a list of applicants and a list of shortlisted candidates, gives the impression in the public, which may be erroneous, that there was a particular set of candidates that were preferred by a particular group, hence the need to fast-track this process and run away from what will have otherwise been a legitimate public scrutiny and inquiry. And you remember, last week, the Law Society of Kenya had made it quite clear that it will meet up on Wednesday, that is today, and set up guidelines that they would like the Judicial Service Commission to take into consideration when looking at these reviews.
Right.
And I think the uproar that may have come about today is because, so to speak, the legitimate expectation of the public and the Law Society of Kenya has been defeated by this process.
All right, but two things you raised there that I want to get back to. One is, isn't there a need for expediency looking at the position we find ourselves in? No Chief Justice, no Deputy Chief Justice. Because that is not what, was envisioned by the drafters of the Constitution. There should not have been a gap. So for JSC to be moving at speed, isn't that something that should be encouraged? And number two, were they perhaps not kicked out or rejected because it was just the basics that they did not meet? What do you think?
First and foremost, it is a situation that Kenyans have never imagined the consequences in case, one, a vacancy occurs in the office of the president. What will happen? Because right now, there is no deputy CJ. There is no judge who can execute the mandate of the CJ. Right now, students at the School of Law who are supposed to be admitted by a CJ. It's all over in the stories. They want to demonstrate because they are saying we need to be admitted. The law talks of within 90 days after gazettement, those students must be admitted by a CJ. The only person present now is a principal judge of the Supreme Court, that is Justice Mohammed Ibrahim. So therefore, the urgency of this matter demands that, in my own perspective, they could have forgotten about the deputy CJ. They proceed dealing with the question of the CJ, complete that, forward the name to the president forwards it to Parliament. As a matter of urgency, Parliament either approves or rejects so that the process starts afresh. Because we cannot sit and look at a serious constitutional dilemma in case anything goes wrong. Two, you've raised also the question about whether they should give these reasons. I've said JSC will be forced by the public, one, to give those reasons. And the reasons are very, very simple. In the checklists, when they talk about integrity, I'm alive that they will have gotten certificates from not less than 6 to 8 government institutions. The KRA, the Credit Reference Bureau, the CID, the Ethics and Anti-Corruption Commission, Higher Education Loan Board, and very many other organizations, the Law Society of Kenya, and very many other. I do not believe very many of the applicants complied with this. And that is, on a casual look, very many of them were disqualified on the basis...
Which is possible.
Possible that on clerical basis, they were knocked out.
Okay.
You've already seen one Court of Appeal judge, Justice GBM Kariuki, saying he could not be issued with a certificate from the Directorate of Criminal Investigation Department. That tells you that there were very many applicants who were found off guard. They did not prepare their documents in time for the applications to be done. And also, there were other people probably who have not practiced for 15 years. There are other people who, for example, there is a story that Professor Makau has never practiced law or taught law in a Commonwealth country for over 15 years. He has been practicing and teaching law in the US, a civil legal system. So, in my view, JSC must have looked at all these technicalities and found out that the only suitable candidate are 6.
So you agree with the JSC?
I agree with the JSC. And for example, if all of them met these qualifications, were they all of them to be shortlisted? They could not. There must be a way to sieve out the applicants. If they applied 1,000 people, they could not be able to shortlist the 1,000 people.
All right, so let's run through the 6 that have been shortlisted. Javi, let's begin with Al-Nashir Visram. And one of the issues, and some perhaps will remember in 2011, it was when then President Kibaki appointed him as Chief Justice. So perhaps he's tasted, smelt the Chief Justice position from a distance. However, that being reversed because under Grand Coalition, there was the issues of consultation, so he never quite got in. But do you see him as a potential candidate? Does he fit being CJ?
Justice Al-Nashir Visram fits the bill very well. He has so many years of experience as a High Court judge, as a Court of Appeal judge. And I think from my limited knowledge of what may be said about the judge, he also has very good leadership qualities, both within the judiciary and outside the judiciary. I think he's well learned. He has a master's degree from the University of Nairobi. He has participated in several managerial positions within the High Court and the Court of Appeal. For a particular point in time, he led the Rules Committee. Currently, he heads the Criminal Division of the Court of Appeal. And I think he also is the person in charge of the Mediation Committee. And I think these are officers that demonstrates one's capacity to be a manager over and above the ability of this candidate to be a good judge, which of course we have seen over the time. And I think based upon that yardstick and the fact that he appears to be very senior amongst all his peers, of course, save for the fact that Justice Mokin Wanjala is a judge of the Supreme Court. I think Justice Al-Nashir Visram will come out as an individual who has the ability to bring unity, to bring harmony, and to bring cohesion amongst his peers. But I think I'll give him a good score for a Chief Justice.
On a scale of 0 to 10, you'd give him 10 being the best?
I'll give him 8.
8.
Yes.
However, there are those who'd wonder whether he's then over the years been able to shed off the tag of establishment. Yet, yes, of course, the regime has changed. We're no longer in the Grand Coalition, but that he had been the choice candidate then under President Kibaki. That now, does he perhaps still carry that with him briefly?
I think that kind of profiling has to be associated with a particular kind of people who may want to push this agenda. Well, in 2011, who was in office other than in a position within the then PNU government? So whoever was in office by that time was serving the government of the day. And I do not think Justice Visram applied for that position. He was nominated by the president.
Okay.
It had nothing to do whatsoever with him. And I think the president must have seen it fit at that particular point in time to appoint him. And that notwithstanding, the judge passed through the vetting process. If there was anything untoward that was raised against the judge, it was weighed against the scales.
Okay.
And it doesn't matter anymore. I think that should not be a consideration anymore.
All right. You can give me your thoughts on that as well, Omari, but also let's move on to Smokin Wanjala, who's a judge, of course, of the Supreme Court. And there are those who feel that he perhaps has an unfair advantage by virtue of these are his colleagues that are running this process, the JSC. He's a representative of the Supreme Court and the Judicial Service Commission. Of course, he will not sit during the interviews, but these are his colleagues, and by virtue of that, there are those who will say, yeah, he has some advantage. What do you think?
First and foremost, I'll only critically look at Visram briefly. To me, I agree totally in terms of what counsel says in terms of capacity to deliver his number one. The biggest problem, as you raised, is the question whether he can be able to shed off the tag as a pro-establishment person. Remember, there was talk that because two arms of government are headed by people from Mount Kenya region, there cannot be another Mount Kenya person heading the judiciary. And therefore, they did not, if you look at it, they did not shortlist anybody from Mount Kenya region. But now, I do see that he lost that job in 2011 by virtue that he was seen to be a pro-PNU person, therefore a pro-Mount Kenya region. There is likely to be some disquiet from court section saying that, yes, he does not hail from Mount Kenya region. It's true, he was born in Kisii, but he is pro-Mount Kenya region. And therefore, that tag of Jubilee might make his being appointed quite emotional. So that is the only reason that Visram might find it quite hard to convince anybody. Two, he was appointed by the former president Mwai Kibaki. The constitution was very clear at that time, and it has never changed, that it is only the JC. The president had no powers to appoint a chief justice. Justice Visram did not refuse the nomination. He accepted willingly and said, thank you very much. I've been appointed a chief justice. So the question that he'll be asked, which fidelity of the law is he going to tell people he subscribes to? When he willingly took a job, he knew that the president had power, didn't have power to appoint him. Therefore, that might be the reason that he'll have a big problem. Let me come to the question of Dr. Smokin Wanjala. Smokin Wanjala comes as a real insider into this game. One, the JSC, he sits as a member. Two, there is perception that he is the blue boy for the retired Chief Justice, Willie Mutunga. Three, there is perception that the Chief Justice who went out is trying to make sure Smokin takes over this job with a view of continuity, with a view of covering any procurement issues that might have arisen under the JSC. Remember, the JSC was being probed by the Public Accounts Committee in Parliament. Those issues are still pending. And therefore, there is a feeling that the members of the JSC might collude to retain one of theirs as the CJ with a view of not bringing any outsider into it. And that is how Smokin Wanjala's candidature becomes quite very critical. Two, as we sit today, there is no official word whether Smokin Wanjala was sitting to review his own application. He's a member of the JSC. Did he sit? Has he disqualified himself from sitting in the JSC? Those are issues that are pending that Kenyans will want to know. Lastly, when you look at Smokin Wanjala, he comes with some qualities that all the other six don't have. One, he has worked with the executive. He has been one of the senior directors at the Anti-Corruption Commission. And one of the recommendations, very critical in Chapter 6, comes from the Anti-Corruption Commission. is there a possibility that his colleagues he left at the Anti-Corruption Commission might have made other contestants not be able to get clearance from the Anti-Corruption Commission? So that experience that he brings at this level overshadows all the others. He's also coming from the academia, plus that area of the Anti-Corruption Commission, and he is the senior most judge in the Supreme Court who sits and has been.
All right.
So Smokin Wanjala comes as a very formidable candidate in this area. Lastly, when you look at his ethnic background, he comes from the popular Zuluya nation. There are overtures that Jubilee will want to have the western part of the Republic vote for it. Will Jubilee agree and support the candidature of Smokin Wanjala? Okay. If that goes that direction, then Smokin Wanjala is the guy to beat.
He's the guy to beat. Quite some analysis you've done there on candidature of Smokin Wanjala. I want to hear your thoughts on him as well, Harvey, but also as we take a break on Rosalind Nambuye, who's the only woman, female candidate shortlisted for Chief Justice, but also DCJ position. And of course, later as we're talking about DCJs, you know, the question that many have asked is now DCJ a reserve for women, because all the candidates there are women. So we take a short break here on The Last Word. Stay with us and keep your thoughts coming. Who is it you'd prefer to be the next Chief Justice? Visram? Is it Wanjala Smokin, Nambuye Roslyn, David Maraga, Kitonga Nzamba, or Mbogoli Msaga? Tweet me at Sophia Wanuna. And also whether you agree with the Law Society of Kenya that JSC make public the criteria they're using to shortlist the candidates, reject those that have been kicked out of the race. We are back shortly. Good evening and welcome back to The Last Word, focusing on the Chief Justice position for which the Judicial Service Commission yesterday shortlisted 6 candidates, and since then LSK demanding to know why the other 8 candidates were rejected. Today JSC as well unveiling the list of the 13 shortlisted for the position of Deputy Chief Justice, all of them women. One of them is Rosalind Nambuye. She's also been shortlisted for the CJ position. Gentlemen, I'll begin with you, Harvey. As you give me your thoughts on Smokin Wanjala, we had what Omari had to say about him. Talk to us also about Rosalind Nambuye, because this is a judge who in 2003 was found unfit by the Justice Ringera-led team over graft allegations. However, she was later reinstated. She was then later again found unfit by the Sharad Rao team, which is a judges and magistrates vetting board. And this is over matters of delays with the issues she was handling in court. She appealed the same, and the matters, of course, she was found now to be fit. So 2 cases there where her suitability has been questioned to continue serving as a judge in the judiciary, but has managed to survive, and now she wants to be at the helm. Do you support her candidature?
Well, there can be no doubt. Let's start with Dr. Smokin Wanjala. There can be no doubt the fact that Smokin Wanjala was closely associated with the retired Chief Justice Dr. Willie Mutunga, and therefore by extension also associated to the forces behind the tenure of Dr. Willie Mutunga. And in the recent past, we've heard of those forces as being led by senior advocates who call themselves the reformist group.
Right.
And it's now quite clear that whereas the reformist group was quite eloquent that their preferred choice for a Chief Justice was Professor Makau Mutua, I think their preferred choice, Dr. Smokin Wanjala. And the very good doctor, who is a very good teacher of mine, I think is closely associated with them. And his success in this race will entail the continuation of the legacy of Dr. Willie Mutunga. Now, I think my colleague Dunstan talked about the issues that could have informed the refusal to shortlist the remaining candidates. And I think one of them was an issue of leadership and integrity. Now, In 2013, a tribunal was formed by the president to try certain members, certain commissioners of the Judicial Service Commission. And key amongst these were, of course, Dr. Smokin Wanjala, and I think a representative of the Law Society of Kenya to the Judicial Service Commission. Now, despite the fact that the workings of that tribunal were put to a halt by the court, those allegations were never put to a close. They are still live in Parliament. And as early as January this year, the Public Account Committee recommended that 6 of those commissioners, including Dr. Smokin Wanjala and Mr. Mednasir Abdullahi, Justice Mohamed Wasame, Honorable Ominde, be investigated by the Ethics and Anti-Corruption Commission. Now, if these investigations are still outstanding, it raises a question. If at all one of the requirements was integrity and leadership that was used to cut off some of these candidates, how did Dr. Smokin Wanjala pass through that test? And I've also seen in the media a profiling and a vote being taken as to who will be the most preferred candidate. And I think some of these polls that are being, I believe you're not taking one of these polls, but I've seen some of these polls.
It's important.
Will be a preparation for the public. It's an acceptance preparation as to the likely candidates that certain individuals may want to take over this position. Now, I think that is as much as it goes on the candidature of Dr. Smokin Wanjala. Now, as regards Justice Rosalind Nambuye, I think she's the only lady shortlisted for the Chief Justice. She's very competent by all means. She served in the judiciary for a long period of time, and I don't think she can be faulted on account of what is so-called the judicial purge that came in with the entry of Chief Justice Evans Gisheru. Neither can she also be faulted with the accusations that she met during the vetting process, because those were issues that were interrogated and were found to be wanting. And that's the reason that she continued sitting as a judge. And I think in the realm of law, once an issue has been finally determined, it cannot be reopened. And I do not think these issues will be brought forth. If at all they are brought forth, I think the only answer to them is that they were dealt with before. They cannot stand on her way of becoming Chief Justice. And I think in all fairness, she stands out as one of the few lady judges that we have who is very bold, who has participated a great deal in the growth of the law. At one point in time when she sat in the family division, when she sat in the lands division, there was tremendous growth in the contours that she created in the development of law, areas that many other judges will have not been bold enough to venture into. So I think we give her kudos. She will make a good Chief Justice.
So in the event she made it for Chief Justice, she's also been shortlisted in the DCJ position, and they're all women for DCJ. We definitely cannot have a situation you have CJ and DCJ from the same gender. So what does that then mean going forward from where you sit if we're to have CJ woman and all the candidates so far and those shortlisted are female as well?
The Constitution is very clear that there can't be the head and the deputy from the same gender. Therefore, what we are discussing is academic. One Justice, Lady Justice Nambuye can only be considered in this discussion on the position of a Deputy Chief Justice. Because now...
What do you mean? What if she wins in the CJ race?
What we are saying is that there is no way she's likely to win, considering that the Deputy Chief Justice's position has completely only attracted ladies.
But what if they re-advertise?
It will be an effort in futility for one Lady Justice Nambuye to continue appearing for the interviews of the CJ, but she'll only be appearing, as I've said, on an academic basis. And that's why she has been shortlisted for the Deputy Chief Justice's position. But in case she now wins the position of the CJ, therefore, all the people who have qualified for the position of the DCJ will have to be thrown off. A new advert must be put in place for the male applicants to apply, which to me, I find it practically not possible. And therefore, that's why my position is that in the race to the position of the CJ, one already technically has fallen off. So instead of 6, we have 5. As I proceed also to say that there will be another one, as we discuss, who I'll see is also going to fall off technically, so that we have only 4 serious candidates in the race for the CJ. So but she's a competent judge, qualified, except that I will only comment her in her position as a deputy CJ.
Justice Mbugoli Msaga, the principal judge at the High Court, found unfit once by the Ringera-led commission, however later reinstated, also in the race and shortlisted for CJ. What do you think about him, Javi?
Well, most of the victims of that purge it was 2004. 2004. I think it was an exercise of trial and error, mostly error. And I think many of the judges who faced the tribunals that were set up against them were able to prove for a fact that the allegations against them were not well-founded. And I think Justice Msaga Mbugoli was one of these judges, a very hard-working judge. He served in the judiciary since a tender age of 34 as a High Court judge. And he happens to have been the person who came second after Justice Dr. Willie Mutunga. Now, much as he is equally qualified as the rest of the judges, I think in the legal profession and any other profession, a leader is always sourced from the higher hierarchy. I think in considering the suitability of Justice Msaga Mbugoli, it needs to be taken into consideration that he will be jumping several steps. He'll be jumping the Court of Appeal, he'll be jumping the Supreme Court to end up sitting in the Supreme Court with judges of the Supreme Court and also be a Chief Justice.
Well, there are outsiders who jump being any of the courts.
Yes, they are outsiders. Well, and I really do not think it's a good idea to invite outsiders in the business of insiders. And the tenure of Dr. Willie Mutunga really showed us how wrong that is. But I think Justice Msaga Mbugoli is a very good leader. He's a very good judge. He will make a good Chief Justice. And
then there's Maraga David, Court of Appeal.
Well, for Justice Mbugoli, I also concur with my learned colleague that by virtue that he's a High Court judge, he could have aspired to become a Court of Appeal judge first, or jump to the Supreme Court judge. So.
But he was second, you said, on the CJ.
That time the perception was totally different. It was a coalition government. There was quite a lot of politics that was there. In my own view at this time is that there is a belief now of seniority upwards. As he says, that time there was a feeling of outsiders coming in and anybody can jump the queue. In management, that brings about a very serious question. Fils has been a very junior judge in terms of seniority. He operates at the High Court. There are 2 layers before the Chief Justice. There is the Court of Appeal, there is the Supreme Court. He will find it completely impossible to manage and give directions to these very old, very senior judges than him. And therefore, it will bring a cock-up or a lock-up in the judiciary. And one of the fundamental challenges the Chief Justice Mutunga's regime faced is lack of leadership and firmness in terms of administration. The Chief Justice was busy transforming in infrastructure. The real administration and management of his people was not properly done. And that is why you saw quite a number of his deputy CJ going out, Nancy Baraza, his chief registrar, Sholei Boss, carrying out. And therefore, I think this time the JSC is very clear that they want a proper structure to be in place. And therefore, that is why Mbogoli does not come in. You've raised a question of one David Maraga. David Maraga comes from practice as a very serious, accomplished advocate in Nakuru. He also comes in as a very senior judge in the Court of Appeal. He also comes in through as a lecturer at the University of Nairobi. To me, he brings three types of expertise that will make him a formidable challenge. And in my own perspective, he comes from a community that is small. He does not polarize the judiciary. He is well respected within the legal fraternity. The only challenge that one David Maraga might face is that will the political class accept his neutrality? If that neutrality becomes an asset, then he is the person to battle it out with one Smoking Wanjala. And in my own perspective, I do vouch that that would be the best judge to take over the position of the CJ.
All right, and so the 5 candidates we've talked about, all within the judiciary. Let's talk about the last one, Zamba Kitonga, who is an outsider. And from what I'm hearing from you gentlemen, it appears you think it's time that insiders carry the day. So Kitonga, you think his chances very slim?
Kitonga's chances are equally slim. I do not see how the judges in the Supreme Court, the judges in the Court of Appeal, and the judges in the High Court will want to be led by Mr. Zamba Kitonga. I think this is an unnecessary trap that is being set up. And also, we need to interrogate his background. He is closely associated with the pro-Mutunga individuals. He may not be a safe pair of hands for us to have as a Chief Justice. And more importantly, he participated a great deal in the promulgation, in the process that led to the promulgation of this new constitution. And I think as a matter of good caution, the individuals who did this noble task ought not to have been allowed to assume any constitutional offices created under the new constitution, because they had a very good knowledge of the background underlying the formation of some of these commissions. And I think for good reasons or for bad reasons, they may end up exploiting that knowledge to the disadvantage of the process intended in the creation of these offices. So for that reason, I mean, I wouldn't give him my score.
Yes. All right. So we have a little bit of a few minutes to go, I understand, before we wrap up the show. Let's talk about some of those that were rejected by the JSC. Begin with Jackton Ojwang, a judge of the Supreme Court. Some have asked a basic question. Why confirm one judge of the Supreme Court and reject the other? What are your thoughts? Do you wonder as well?
First and foremost, Professor Jackton Ojwang is the most learned among the people who are applied. He has 2 PhD degrees in law. The only challenge is that the JSC wanted the judges to retire at 70. Professor Jackton Ojwang's argument and decision was that retirement is 74. He actually went against the decision of the JSC. He has applied to go for unemployment before the same JSC. Definitely, it was an academic exercise for him to put his papers in.
But really, are you saying the JSC is kicking out anybody who disagrees with them? Because surely...
Well, we know it that the JSC will want somebody who believes in what the JSC's policies are. And the professor has, even if you look at the body language and the judgment, that his body language was a body language of a judge who was fighting the then Chief Justice.
Okay.
And therefore, from anybody who could see his language in his judgment and the way he postured, there was definitely a serious question whether he's intending to apply for the CJ's post.
All right. Then there's Makau Mutua, a lot of reactions on social media following his rejection. Were you surprised that he didn't make it, and there was information that he'd sent quite a bulk of paperwork, quite a CV to the JSC, Harvey?
Permit me to speak both about Justice Ojwang and Makau Mutua.
Yeah.
I think for Makau Mutua, we will not spend so much time on it. Professor Makau Mutua was a decoy. He was dead on arrival. Everybody knew that he would not make it on the threshold requirement. I think there's not much lamentation about his failure to meet the shortlist.
Why?
Professor Makau Mutua has never practiced law in Kenya. He's never been admitted to practice law in Kenya. He has been an academician in the United States, which is not a Commonwealth country. The Constitution is quite clear. The 15-year minimum requirement, both on academia, on the bench, or on the bar, relates to individuals within the Commonwealth.
All right.
Yes.
And for...
Now, Professor J.B. Ojwang, my very good teacher from first year and second year, has the personality that you see of him. So when we hear people saying that he's a man of bad temperament, I think these are people who do not understand Professor Justice Ojwang. This is a very credible judge. He's a very credible leader. He was the dean of the law faculty for a long period when we were at the university. And I think the manner in which he conducted himself during the hearing of the Justice Tunoi and Rawal case was not any different from the manner in which he behaves to those who know him.
Yeah.
Now, but what we need to take into consideration are the undertones behind some of these overtures. I think it's quite apparent from October last year that there was a group of people who were keen to ensure that certain judges in the Supreme Court will not participate in this recruitment exercise. And we said this much earlier, and we have now been proved right. I think several petitions that were put before the Judicial Service Commission, which have not been determined, or which have been determined in a particular way, may have been used as a trap to preclude individuals like Justice J.B. Ojwang from passing the minimum threshold requirement. And I think that is quite unfortunate.
Right.
The reason being that it's quite evident it's being targeted because of the perceived notion that he was anti-Dr. Willie Mutunga. And I don't think that is proper.
And okay, let's talk about GBM Kariuki as well, who's a judge of the Court of Appeal. He had intended to apply for the CJ position, however, did not manage because he did not have all his paperwork ready. And he's now threatening to sue the state. He says the DCI's office, Director of Criminal Investigations Office, declined to give him a certificate of good conduct. This despite it having been issued to him in 2 other occasions, and he's reading malice and sabotage. Do you agree with that?
Well, we do not have facts because that is an allegation.
Yeah.
Justice GBM Kariuki saying that the DCI was either late or had reasons as to why that certificate was not issued. Until he files that matter in court and produces evidence, then the DCI responds and produces evidence as to why that was not produced, then we can talk about it. But if indeed he was denied a certificate of good conduct without justifiable reasons, then the DCI will be in great problem.
Okay, we have 1 minute to go. As you give your last word, kindly comment as well on the composition of the JSC. I know it's a heavy subject, perhaps it would require much more time, but in as far as whether you're confident, first with the structure in terms of the representatives we see sit there and the individuals currently in those positions, Javi.
Now, I think I'll pick a leaf from the publication in the Daily Nation of Friday and Saturday, written by lawyer Gitobi Manyara. He made it quite clear, and we know who Gitobi Manyara speaks for. I think he speaks for the so-called reformist. He categorized some members of the Judicial Service Commission, being one judge of the Court of Appeal, a judge of the High Court, and a magistrate, as being those who are reformist within the Judicial Service Commission. And perhaps if you look at it from that perspective, those are the commissioners to watch insofar as it relates to what particular direction they may want to pursue this recruitment. I think the rest of the commissioners, and even including these 3 commissioners, notwithstanding that profiling by Gitobi Manyara, I believe ought to be independent commissioners with the ability to make an objective decision on this issue.
Right.
Because this is not a personal issue. It is a bigger, wider issue that concerns Kenyans. It should not be belittled down to the interests of key individuals who may want to label themselves as reformists for purposes of pursuing an agenda which does not serve the interests of wider Kenya.
All right.
Yes.
Finally.
My final submissions on the JSC, I look at JSC as a mongrel. Really, where a magistrate interviews a chief justice, where a person sitting in the JSC applies to be the chief justice, where the judges who are aspiring to be Supreme Court judges, are aspiring to be Court of Appeal judges, are sitting before this. We need to relook at the composition of the JSC. We have lawyers who are members of the JSC, by courtesy of them representing Law Society of Kenya, who appear before the same judges, who are commissioners. Therefore, these lawyers are employers of those judges. So really, it is quite a mongrel that I do not expect them to be independent, to be transparent, and to decide matters extraneous that in the way they are composed.
Right.
Lastly, Sophie, there's something we forgot about Nzamba Kitonga. Nzamba Kitonga comes from the Kamba Nation. Justice Mutunga retired 1 year before the term of the Kamba Nation ended. Isn't Nzamba Kitonga going to get this position because Justice Kaiseri took over from Molelenku? We have seen that type of Kimaiyo left, Boynet took over. Isn't Kitonga going to argue that, wait, we as the Kamba Nation have 1 more year remaining, so this is our job? We might have it, but I don't count him there. In my final submissions, there are only 3 serious contenders. There's a possibility of David Maraga leading the pack, followed by Smokin Wanjara, and the 3rd contender being Visram. That is my preference.
All right. Thank you, gentlemen. Dunstan Omari and Nelson Habi, both lawyers, for being with us tonight. So the next 21 days is for the public, whoever may want to be able to participate, give their views, to submit. Where do they do that? At the JSC? Do we know?
They will do memorandums. They will write. As now we are discussing, the public will participate.
Okay.
They will swear affidavits. They will write whatever they want to do.
All right. Yeah. And of course, this time around, the JSC is saying they would be able to, before the public interviews, allow for the candidates to see the accusations, if at all, leveled against them, so that they're not seeing and hearing of them the first time when they're in front of the camera and before the public. Let me quickly read some of your views tonight on the subject. Ogeki Araka, you say, LSK demand for criteria used for CJ shortlist is fair, judiciary-only arm of government, hardly subjected to popular vote. We also have another tweet here that reads, Victor Mshindi, application for public service is private, not public. The applicants receive private notification of their progress. One more before we go. I'm told our time is up. GKK Kulabusia, you say he doesn't deserve it, and you're referring to Mr. Makau Mutua to be on the short list. And of course, very many other views there. We appreciate you taking the time to tweet in tonight. Unfortunately, we must wrap it up. My name is Sophia Wanuna. On behalf of all that made the show possible, we thank you for watching tonight. Enjoy the rest of your viewing, and God bless you.
Thank you.
Good night.
Thank you.
KTN News. Get the whole story.